Hey there, welcome back to Constitutional Studies Week 9. This week we focus on a part of the Constitution, a distinct chapter called the Directive Principles of State Policy. This chapter, Chapter 4 of the Constitution, is one that has generated a fair degree of confusion for the courts, for parliaments, for law students and lawyers alike. It's a novel and interesting part of the Constitution that carries a significant historical burden, the burden of the transformation of India from a poor, developing country into a modern country free from the ravages of economic inequality and social inequality, and ready to embrace the world in the spirit of scientific inquiry. So it's quite a broad agenda for social transformation, which is captured in Part 4 of the Constitution, but one that has received very little attention, intellectual attention and legal attention over the years. In this lecture, I will introduce you to this part of the Constitution and take you through some of the main debates that occurred both prior to the Constitution and soon after the Constitution's adoption, leading up to the turn of the century. The broad outline of this lecture will be to first introduce some historical antecedents to the Directive Principles of State Policy. Its novelty doesn't mean that it was invented out of thin air. Similar experiments existed in a couple of constitutions and had been spoken about in Indian political history of the freedom movement. We then trace how the Directive Principles came to be placed in Part 4 of the Constitution, and then inquire whether these principles are best thought of as legal or as political principles, and what would that mean in practical terms. Finally, we close with a short take on the evolution of these principles from relative backwaters of the Constitution in the 50s to emerging quite center stage at the turn of the century, and is likely to be very important in the decades to come. So let me get started by tracing some of the early historical antecedents to the Directive Principles chapter. Now, the Sapru Committee of 1945, we've done this kind of historical tracing through much of this course, and I think by now you're familiar with this method. It's very important for us to understand this background history, or else we end up with rather truncated or minimal understanding of the constitutional provisions as they are. The Sapru Committee of 1945 was the first Indian document to engage with the issue of dividing rights into justiciable and non-justiciable categories. Now, you remember in the last session that we discussed the Karachi Resolution, which had already embraced a wide degree of social and economic rights as being part of the Purna Swaraj Declaration that India should be committed to, Gandhi's plan of action to make the freedom movement appeal to the wide masses of this country. Article 5 of the Karachi Resolution spoke in terms of the protection of women workers and making adequate provisions for leave during maternity and so on and so forth. Even earlier, prior to the Karachi Resolution, the Nehru Report of 1928 had already anticipated that all citizens in the Commonwealth of India shall have the right to free elementary education, and that a suitable adjustment of time may be given for the enforcement of this right so that adequate resources could be made available. It was this kind of tension between granting wide social rights, rights to social welfare goods to be provided by the state to citizens at large, and the lack of adequate resources that seems to animate the Sapru Committee report in 1945. The Sapru Committee report was the first to divide up these kinds of commitments to liberty and equality and fraternity on the one hand, and commitments to social and economic rights on the other into justiciable and non-justiciable categories. Let me spend a minute to explain this. Justiciability means, is it amenable to a court's jurisdiction? Can a court of law consider these rights and interpret and implement them? The Sapro Committee was the first to hint that maybe some of these social and economic rights should be put into a bucket where they were not enforceable by the courts. So, the future drafters of the Indian Constitution in the Constituent Assembly picked up on these concerns. T.T. Krishnamachari was one who was quite skeptical of the move to treat Part 4 of the Constitution as being non-enforceable by courts. He suggests, and I read, in view of the fact that quite a number of new items have crept into this part which might be called a veritable dustbin of sentiment, I see no objection actually to this or any other amendment coming in, because this dustbin seems to be sufficiently resilient as to permit any individual of this house to ride his hobby horse into it. You can tell from T.T. Krishnamachari's acerbic tone that he was no fan of the design of Part 4 of the Constitution, nor was he a fan of the content, the principles that went into Part 4 of the Constitution. Ambedkar, though, took a slightly different view. He suggested that, unlike Krishnamachari, it was not his intention to introduce into this part principles as mere pious declarations. They should be made the basis of all executive and legislative action that may be taken hereafter in the matter of governance of the country. So Ambedkar took the view that committing principles to legislative and executive action was not simply a pious declaration. It was just a division of labor between the various organs of government. While the judiciary might have primacy with respect to the enforcement of fundamental rights, the legislature and the executive will have primacy with respect to the implementation of the directive principles. Now, the directive principles are a wide chapter of principles, and to the extent that Krishnamachari is skeptical about whether something holds them together, he may well be right. But having said that, let's see what we ended up with. We ended up with the chapter, Part 4 of the Constitution, which runs from Article 37 to Article 51. But there are different kinds of principles in the chapter. First, one notices that there are principles that could best be described as socio-economic principles. Equal pay for equal work, humane conditions of work, living wage, all related to labor, to questions of labor. There were principles on which a common agreement could not be found, and those principles were deferred in the constitutional making exercise, left to a future legislature or future executive to decide. The Uniform Civil Code, alcohol consumption, and cow slaughter seem to be topics that could not be settled by the Constituent Assembly as they were, and had simply been deferred. A third set of principles in Part 4 of the Constitution appear to be those principles that are broad principles that apply to various fields, ranging from historical monuments to a principle of the separation of powers, and one promoting international peace. But we can't go too far while discussing Part 4 of the Constitution without talking about the two key principles in Part 4 of the Constitution. The first of these is Article 37. So we will come back to 37 discussions at a later point when going over early discussions on enforceability. But let me say this much. The provisions contained in this part shall not be enforceable by any court. but the principles therein laid down are nevertheless fundamental in the governance of the country. And it shall be the duty of the state to apply these principles in making laws. Now this core principle, 37, you can call it the gateway article to Part 4 of the Constitution, makes two or three elements clear. Not enforceable by court, nevertheless fundamental in the governance of the country. A legislative and executive duty to implement these principles, to apply these principles. This was the structure of 37, but equally important are the two key provisions of Article 38 and 39, which set out two broad principles. First, the principle that the state must act in a manner that promotes the welfare of the people at large, and second, that the state must act in a manner that minimizes inequalities in income and inequalities in status, facilities, and opportunities. 39 goes even further. It assures that everyone should have a right to an adequate means of livelihood. That's Article 39A. And it follows up with rather strong principles against monopolies by suggesting that the ownership and control of the material resources of the community are so distributed as to subserve the common good. It also seems to put in place a principle of competition, that the operation of the economic system does not result in the concentration of wealth and the means of production to the common detriment. These kinds of principles of economic and political design, are not commonplace in constitutions. While the Constitution of Ireland does provide for some broad socio-economic rights for the guidance of the legislature, it is not anywhere close to being as broad or substantive as the Indian provisions. Ghana and Nigeria have followed India in part by adopting a mix between enforceable and non-enforceable fundamental rights. But once again, these jurisdictions don't have the same width and breadth as the Indian Constitution. So let me stop with the overview here, some broad principles in Part 4 of the Constitution. And what we are trying to do in the next stage is to move on and understand what is this distinction between enforceability, between fundamental rights and directive principles. If one turns to Article 13, Clause 2 and Article 37, and maybe we should read Article 32 of the Constitution as well, we understand that while fundamental rights are phrased in negative terms, which is that the state shall not make any law which takes away or abridges the rights conferred by this part, in directive principles, the state has a positive obligation. The state shall apply these principles in making laws, and these principles are fundamental in the governance of the country. Conversely, while in fundamental rights, in Article 32, the Supreme Court and the High Courts in Article 226 are empowered to enforce these rights to the detriment to strike down state and executive action. In Article 37, it makes it very clear that the provisions of this part shall not be enforceable by any court. Let's add this together. Fundamental rights, state cannot take away or abridge. Directive principles, state shall apply these principles in making laws. Fundamental rights, the court shall enforce fundamental rights and strike down state action. Directive principles, the court shall not enforce these principles. It's left to the legislature. So you notice, as a matter of institutional design, that Part 3 and Part 4 of the Constitution adopt, at least as an institutional matter, complementary approaches. While one endows the state with power, the other takes away state power. While one endows the court with the power to enforce, the directive principles takes away the power of the court to enforce. A second distinction is important here, and that distinction is the distinction between enforceability and justiciability. In an earlier slide, we had used the language of justiciability while talking about the historical antecedents to Part 4 of the Constitution. But the Constitution chose to only make laws, directive principles, not enforceable by the courts, but they may be justiciable by the courts. What may the distinction be? I'm going to suggest to you that the distinction is simply one between primary enforceability of the primary role of the court to enforce these provisions as distinguished from the secondary ability of the court to take into account, to take cognizance of the principles in interpretation in other ways, but not directly enforce them. So the gap between enforceability and justiciability allows courts to have a secondary role, but not a primary role. So much for the distinction between directive principles and fundamental rights. And what you will notice is that this approach to directive principles that I've tried to sketch out for you so far is not one that is commonly found in the literature, in the academic literature, or in the commentaries in this field. And hence, I recommend to you that we might do well to illustrate it a little bit more before we look at how the Indian courts have applied this area of the Constitution. To summarize, what we've suggested is that the political constitution, which is implemented by the political branches of the government through actions of legislation, executive action, and budgetary spending, is what the directive principles is where the directive principles belong. The legal constitution, that is the constitution as rules of law, allow the courts to undertake a secondary implementation of the directive principles as an interpretive tool to fill in gaps and shape constitutional interpretation, to enforce action taken by political branches, to nudge political branches to act. This was how the Constitution was designed, and Part 4 of the Constitution gave a clear emphasis to the political branches of government and de-emphasized legal implementation through the courts. However, this division in legislative, executive, and judicial role was not one that was well understood either in the 1950s or, for that matter, as we turn the century in the first 2 decades of the 21st. So let's get started and look at how the courts and other institutions have approached this field. In the earliest cases, and the earliest case was a case called State of Madras versus Champakam Dore Rajan, 1950, one of the earliest cases before the Supreme Court itself. And the question before the court was whether affirmative action, reservation quotas for non-Brahmin communities in the state of Tamil Nadu was constitutionally valid. Now, there was a provision in the directive principles which suggested that these kinds of affirmative action programs was necessary to reduce the inequalities between social groups. However, the Constitution also prohibited in Article 15 discrimination on the basis of caste. The court took the view that a quota for non-Brahmin populations that effectively on the basis of caste, a quota that identified communities based on caste and gave them a special ability to enter medical and engineering schools was unconstitutional because it violated the fundamental rights in Article 15.1 and Article 29.2, but the directive principles of state policy, which mandated that the state must do such things, the court suggested was unenforceable and hence not relevant to the discussion in the case. This was the first case where the court established the priority or the relative importance of fundamental rights over directive principles, a debate that has come to dog the Indian debate ever since. In Muhammad Hanif Qureshi in 1959, the court took a slightly moderate tone. It dealt with the case, it dealt with the law made by the state of Bihar with respect to butchers who made a living out of the slaughter of cows. And the court took the view that directive principles that required some action against cow slaughter or in line with animal husbandry should only be implemented in a manner that was consistent with fundamental rights. Once again, the court suggests that fundamental rights have priority over the directive principles, but does not undermine them in full. In similar cases in Chandra Bhavan and so on, the court has started to moderate this question of the relationship between fundamental rights and directive principles. But by that time, much damage had been done in the field of land reform. What had occurred in that period from 1950 to 1970 was that several land reform laws had been struck down on the grounds that they violated the right to property. This, in the early years, led to the amendment of the right to property, its removal and replacement as a constitutional right. However, the courts were not done yet. In subsequent cases, they still struck down various land reform and tenancy reform legislation on the grounds that they paid inadequate compensation or they did not follow due process in the ways in which they eliminated property rights. In the 25th Amendment Act, the Constitution 25th Amendment Act in 1971, a new provision was introduced into the Constitution, Article 31C. Article 31C took the view that so long as you were implementing Article 39 B and C, there could be no challenge to a law on the grounds that it violated 14, 19, or 31. Now, remember, 39B and C are the provisions that say the ownership and control of the material resources of the community are so distributed as best to subserve the common good. And C says that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. You can imagine that the purpose of Article 31C was primarily to protect land reform legislation and at a later date protect nationalization statutes which were used to push India towards a more socialist mixed economy. This 25th Amendment sparked one of the longest and arguably most significant constitutional battles that relate to land reform laws, and this was Keshavanand Bharati versus State of Kerala. It was the first case in 1973 where the Supreme Court said that while Parliament had the power to amend the Constitution, it could not amend the Constitution in ways that altered its basic features. As far as Article 31C was concerned, a majority of the court took the view that a harmonious balance could be maintained between fundamental rights and directive principles and was willing to uphold this provision. Now, you must remember that this argument for a harmonious balance is a long way from Champakam Dorairajan and the early cases. So between the period 1950 and 1973, the court has effectively changed its mind and put in place a more balanced account of the relationship between Part 3 and Part 4 of the Constitution. Nevertheless, the 42nd Amendment Act was enacted in 1976. It widened Article 31C to include all directive principles of state policy, effectively giving directive principles of state policy a status superior to the fundamental rights in the Constitution. Not surprisingly, Article 31C was challenged in Minerva Mills, and Minerva Mills took the view that as harmonious balance was a harmonious balance between fundamental rights and directive principles was a basic feature of the Constitution. The Constitution could not be amended in a manner that gave primacy to the directive principles over fundamental rights. In this manner, the court moderated its position on the hierarchy, but also tempered the push by Parliament to elevate the directive principles over fundamental rights. This subsequent position, Minerva Mills' position on the harmonious relationship, is now part of the basic structure doctrine and cannot be amended. After 1980, there has been a wave of public interest litigation and other litigation enforcing directive principles as fundamental rights, and the court has been very willing to get into these cases and allow directive principles to be effectively read into Part 3 of the Constitution. These include the directive principles that relate to education, environment, and free legal aid. We have discussed some of these cases earlier in this course, but the court now was effectively interpreting Part 3 to include the core elements of Part 4. In the Constitution 86th Amendment Act, you see that Parliament and the Executive has jumped into the Act and has begun to incorporate some principles that are found in Part 4 of the Constitution, in the case of compulsory education, Article 45, as a new fundamental right under Article 21A. This fusion between Part 3 and Part 4 of the Constitution may seem like some radical new push and transforming our social and legal sphere, but it's not quite what it seems. While the legal form of Part 4 of the Constitution and Part 3 of the Constitution is changing, the capacity of the state to deliver on these promises is not quite there yet, and hence the early debates, as you were made familiar with in the Constituent Assembly, still remain. We can make pious declarations, and if we don't have the ability to implement and enforce them, then just by merely calling them rights, we don't achieve very much. We also run the risk, as we do in Shyam Narayan Chokshi versus Union of India, that a court might decide that in order to cultivate a spirit of nationalism or patriotism, that the national anthem should be played in cinemas. And it may do so based on the directive principles as well as fundamental duties. In either case, the enforcement of directive principles by the courts appears to be, our Constitution framers seem to have chosen well to keep directive principles out of court enforcement and to leave it to future legislatures to make these changes. This gets us up to the early part of the 21st century. We're now at the end of the second decade of the 21st century, and we see that while there is a resurgence of emphasis on directive principles, the core confusions that existed in the early part of Part 4 implementation in the 1950s remain. We still remain unsure about the precise role of the court and the precise role of the legislature and the executive. And these questions remain with us even at the end, at the point at which we are. So to conclude, let me say the following. Part 4 of the Constitution represents a unique and novel instrument in the Indian Constitution, by which I mean much unlike most other constitutions. It's not like the Constitution of the United States, or for that matter, countries in Europe have such a Part 4 model. Second, the directive principles were placed in Part 4 of the Constitution to really capture the transformative goal of the Constitution. You must remember that we noticed when we read the preamble that the Indian Constitution was not historically self-conscious. It didn't talk about colonialism, the ravages of caste, the ravages of communalism, and so on. But Part 4 of the Constitution embraces that background history and prescribes some key principles as being the foundational principles of governance in India. Second, Part 4 of the Constitution, Directive Principles, seems to embrace a model of political constitutionalism as opposed to legal constitutionalism, by this we mean that political institutions are far more important for the mobilization of these principles than courts. It is at least commonplace to say that somehow social transformation in India has been engineered or propped up by the courts as being the real vanguard among the institutions of state. This short history that I've covered for you today should make it very clear that when the political branches of government, the executive and the legislature, were strongly pushing for the implementation of land reform laws as well as other laws of social transformation like affirmative action laws, it was the court that struck down these laws and forced a very strong institutional conflict that willy-nilly led up to the emergency and almost constitutional breakdown in the 1970s. So I've given you a very early hint of why the story of the directive principles of state policy is critical to an understanding of Indian constitutional and political history, as well as Indian constitutionalism in general. For the purposes of an introductory lecture like this, I can't deal with these questions in any greater detail, so I will stop here. But I hope I've provoked enough interest among you to look at the directive principles with care and to imagine what is the kind of political society that the implementation of directive principles is aimed to achieve. So let me stop there. Thank you. We will come back for the last lecture of this course in a couple of days. Thanks. Bye.